May I now have your appearance?
May it please this honorable court. My name is Vincent Kinslet. I appear alongside my learned friends, Laron Wachayari and Matum Makoha, in representing the appellant in the instant suit. I'll be taking you through issues number 1 and 3, while Laron will be taking you through issue number 2, and Matum will be taking you through issue number 4. If this explains the nature of our submission, I beg to proceed. I'll start with issue number 1. To answer the question as to whether the trial court erred in finding that there was no penetration on the minor by the accused. I must say that indeed the finding of no penetration was correct and the holdings and it should be upheld. I have 3 limbs to present before you. I'll start with the first limb that states that there was a contradiction in the prosecution's evidence. I'll start with the first limb, which states that there was a contradiction in the prosecution's evidence. And it was established in paragraph 9 of the fact sheet that the complainant testified that there was a use of condom, yet the establishment that was made by the clinical officer in paragraph 12 states that spermatozoa was found to have started to degenerate. This contradicts the complainant's evidence that was provided. And my lord, if I may take you to the case law of Julius Kioko versus Republic, the case law of 2015. The case law of 2015, the Court of Appeal held that contradiction of crucial facts like penetration creates reasonable doubt, and hence there is indeed a doubt as to whether the prosecution's evidence that she provided during her testimony is indeed correct. And on to my second link, I will state that there was an unreliable DNA test. It was established in paragraph 12 of the fact sheet by the examination conducted by the clinical officer that the DNA test match was only 55%. This indeed is a smaller percentage to be considered, and it is an insufficient proof of that the spermatozoa indeed belonged to that of the accused. And so, as we know that the prosecution's burden is to prove beyond reasonable doubt that the accused is guilty. And by the 55% match, it can't be proved that the accused, Innocent Wabwire, is indeed guilty because the DNA match was only 55%, and this is a smaller percentage to be considered. My lord, if I may take you to the case law of Lumu Kimani versus Republic, 1979, that was held. The court held that evidence provided must leave no room for doubt. And in our instant suit, I must say that there is indeed a doubt as to whether spermatozoa indeed belonged to the accused, as it only matched with 55% of that of the accused. And on to my third limb, I would say that there found out that the hymen was already starting to clean. This implies that the alleged act may have not occurred recently. It may have occurred in the past. And it is questionable as to how the hymen may have started to heal overnight, as it was established by the clinical officer. Between the accused and the alleged sexual act that he was proven guilty of. And my lord, if I may take you to the case of Arab Koril versus Republic case law, it was held that corroboration is needed in sexual offenses unless reasons are recorded. And in cases where there are inconsistencies and lack of medical met. And so the Court of Appeal applied Section 124 of the Evidence Act, and the complainant and corroborated evidence could not stand the material inconsistencies, and hence the accused was found not to be guilty of the act. Similarly to the instant suit, I must say that there was indeed no corroboration in the sexual offense that Innocent Wabwire was held liable for. And so I must say that may it be found in favor of the court that my client Innocent Wabwire fact that he was charged with of defilement isn't proven, as there is major inconsistencies from the prosecution's evidence and also the medical